Welcome to another episode of the Untitled Legal Attempt with me, your host as usual, George Chintankwa Madepilo. Thank you very much for tuning in, and firstly, I would like to apologize for having taken so much time to record another episode. Well, life, guys, life. So sad that we have the coronavirus. Hope everyone is staying safe, and I pray that we will make it out through this difficult time. With that being said, one more thing. I would like to thank everyone who's taken the time to listen to my previous podcasts. We have 170 downloads. I mean, pretty good for a show that is recorded on a phone and with a normal individual like me. Anyway, with that said, shall we now move on to today's case? Now, before I bring about today's case and the gist of the case, I would like to first of all define what a trademark is in the simplest form. So my understanding of a trademark is this is basically a mark that indicates a service or a good of a particular substance, differentiating it from other similar goods or rival competitors. And it also is a linkage in the connection of trade between the trademark itself and the people who own the rights to the trade. Now, having defined a trademark, we can now move on to today's case. Now, today's case is one that borders on intellectual property and, to be specific, issues of trademark. This case is cited in full as D.H. Brothers Industries PTY Limited and Olivine Industries PTY Limited, Supreme Court of Zambia Judgment number 10 of 2012. Now, this case has its genesis from the Registrar of Trademarks. Under Section 51 of the Trademark Act, Chapter 401, it was stated that you could make an appeal to, of course, the Registrar of Trademarks at the time, because his office is no longer functioning, against any issue in relation to the trademark or in connection with trademarks. Now, the brief facts of this case are D.H. Brothers Industries created a trademark known as Daily. So this trademark was used on their products for various products. They used the trademark on their various products. Now, D.H. Brothers Industries did not register that particular trademark. So Olivine Industries, the respondent throughout this matter, on the 23rd day of February 2005, decided to register, or they applied to the Registrar of Trademarks to register the trademark Daily. And they were registering it for bleaching purposes and other substances for laundry use, such as cleaning and polishing. Now, D.H. Brothers Industries opposed the application on the grounds that they were the true proprietors of the trademark Daily, yes, in Zambia, and they had been using the trademark since 2003 prior to Olivine Industries' application, meaning Olivine Industries were not allowed to use the Daily trademark. However, the Registrar of Trademarks ruled in favor of Olivine Industries. Yes. Now, the reason was that Daily did not register the trademark, and as a result, their trademark was unprotected, and they could not then go before the Registrar of Trademarks and prevent another institution from registering their trademark. So unregistered trademarks are unprotected. That was their ruling. If it's not registered, it could not be protected. D.H. Brothers Industries went before the High Court, challenging the decision of the Registrar of Trademarks. They wanted it to be overturned. Now, the argument before the High Court was still the same as before. Prior usage, and they also showed sufficient usage of the property, and also they were the owners of it. They argued to say the registrar was wrong. Now, the High Court, in their judgment, started by saying that what this case was about was whether an unregistered trademark which resembles, I'm quoting from the original judgment, or which resembles or is identical to another mark, which is also registered, could prevent the other mark from being registered under the law and the rules in the Trademark Act. Now, the court looked thoroughly at the Trademarks Act. The High Court stated that when you look at the preamble of the Trademark Act, it does not offer any protection to an unregistered trademark. The preamble of the Act actually states that the purpose is, namely, the registration of trademarks, and if you read it with other sections, it does not offer protection to an unregistered trademark, and that protection is only offered to registered trademarks and not similar or identical unregistered trademarks. And as a result, even Section 7 of the Trademark Acts disentitles a proprietor of an unregistered trademark from coming to court or from commencing actions to prevent or recover damages for infringement. The court threw out the idea that prior usage or sufficient usage for this particular trademark is enough to guarantee protection. So when we get back, we will now look at the matter before the Supreme Court of Zambia, and thereafter, I will basically also throw in my input on this particular issue. So for now, enjoy some pen sound. Welcome back. Yeah, I know you missed me saying welcome back. So the Supreme Court took on this matter, and as it was from the High Court, the parties were still the same. DH Brothers Industries were the applicants, Olivine Industries were the respondents. The ruling of the Supreme Court was in line with the High Court. They stated that based on the provision that they had looked at, Section 17, Section 16, and Section 7, and also the totality of the Act itself, it was clear that the Act makes provisions to the registration of trademarks, and that no other person shall be entitled to institute any proceedings or to prevent or recover damages for infringement of a trademark which is not registered. So meaning your trademark has to be registered for you to prevent anyone else from using your trademark. So if your trademark is unregistered and you then try to prevent another person from registering or using that trademark, you're not protected under the law. There are no damages that you can obtain, or you cannot prevent the usage of an unregistered trademark. The Supreme Court stated, and I quote, "We totally agree with the arguments on the submission on behalf of the respondent and with the appellant, High Court judge, in her analysis of the relevant provisions of the Trademark Act, insofar as they relate to an undisputed facts in this case. It is our conclusion that both the Registrar of Trademarks and the appellant High Court judge were on firm ground when they held that the applicant's trademark daily cannot be afforded protection on account of non-registration, although the applicant has shown sufficient prior use of the mark in Zambia. This appeal fails as it lacks merit and it is dismissed with cost to the respondent to be taxed in default of agreement." Now, what they basically mean is that costs for the lawyers, the respondent is the one that will have to pay them. And if the respondent does not pay the costs, you can take it up to taxation. This is now why you argue to say, we did this, going to court, making arguments. I just thought you would know that. But back to the main principle at hand here. The Supreme Court laid down a serious marker. Trademark registration is of a cardinal importance. If you are going to use a trademark, always ensure that first of all you register that trademark so as you are protected and enjoy the rights under the Trademark Act. It has never been repealed, it's still the same. So you have to enjoy the rights of the Trademark Act. So for you to recover any damages from infringement or to prevent anyone from using your trademark, that mark must be registered. And if it's not registered, you will suffer the consequences like D.H. Brothers Industries, who were told, yes, sufficient usage of this trademark in Zambia you have shown us, but you didn't register it. And therefore, because you did not register it, the law does not protect you because it only protects registered trademarks. Now, registered trademarks are the only ones protected. So meaning, if I want, could steal another person's trademark and it won't be theft because they haven't registered it and you're not protected. So this case laid down a serious marker. Now, a lot of people have said this case also through the case of passing off. We no longer have passing off in Zambia. I don't want to comment on that because that is people's own opinion. Today's case is just looking at the registration of trademarks. If other people have other thoughts on the fact that this case means that there is no longer passing off in Zambia, that's their argument. But for today, we were just looking at the fact that only registered trademarks are protected in this country, and that if you haven't registered your trademark, anyone who comes across your trademark and they register it, you cannot prevent them from using the trademark, or you cannot sue for any damages, prevention, or claim infringement. So that has been today's case, looking at trademarks and the importance of registration of those trademarks. I want to thank you for giving me your ears. My name is George Tintanko Malipiro as usual. It has never changed. We'll be back next week, or we'll be back whenever for another episode on the Untitled Legal Attempt. I'd like to thank everyone who has taken the time to listen or who have listened to all my episodes. We're on Spotify, Apple, and Google Podcast. So yeah, just spread the love and remember, stay safe. So this is me signing out. I will see you next time. Bye.